The Exclusive Emerald Gems Bankruptcy Case. Introduction. Exclusive Emerald Gems is an Australian company that went bankrupt due to the impossibility of fulfilling its obligations. The 5 directors of the company were unable to act together in the interests of the business. Some of them were not competent enough. The company's failure occurred due to 2 factors: a risky large loan that did not match the possible profit and the inconsistent adoption of critical decisions. Liability of the Exclusive Emerald Gems directors. Illiterate management and unequal distribution of responsibility among the 5 directors led to the bankruptcy of Exclusive Emerald Gems, e.g. According to company law, e.g. is a private company where shareholders have limited legal responsibility for the company's debts. However, all company directors are responsible for making joint decisions regarding the organization's development and failed in their fiduciary duty as directors. Section 141 of the Corporations Act discusses replaceable corporate rules, including voting procedures. In the e.g., the voting order is based on the majority vote principle. However, only 2 votes were in favor of expanding the business, 2 were not present at the meeting, and 1 vote abstained. Despite the differences, the decision was made, and everyone will bear equal responsibility for it. A director's responsibility under the Corporations Act relates to conformity with the necessary personal qualities and standards of conduct. The Corporations Act Section 1.5.5 requires directors to act prudently, not to abuse their position, to avoid insolvency and misuse of information. In the e.g. example, these provisions were significantly violated. The directors decided to take out a loan without considering the risks and the possibility of its further coverage through sales. Blake acted in his self-interest, as part of the loan would be used to buy from James Proprietary Ltd., a warehouse and showroom where Blake was a shareholder. Blake abused his position and used the client database to his advantage. The discrepancy between the areas of directorial responsibility led the e.g. to bankruptcy. All 5 directors of the company are responsible for its insolvency. The director is elected to conduct business and represent the company's interests. All 5 directors acted in their interests, which conflicted with the company's. Emma was not present at the company's expansion meeting and made an important decision without knowing the consequences. Her vote became decisive. Dana abstained from voting, thereby not taking part in deciding the organization's fate. Carlos did not insist on his participation in the decision, and his partners did not consider his opinion. The only people in favor of expansion and lending were Aaron and Blake. Aaron could not avoid a conflict with a supplier, losing a valuable collaboration. Blake, acting in selfish interests, stole clients from the e.g.'s base. Thus, none of the directors met the required level of responsibility. Possible defenses and their success. The e.g. director protection strategy must rely on the ignorance of the actions of one of the directors and the subsequent bankruptcy. Directors are expected to have the necessary experience and skills to perform their duties in good faith. The directors of the e.g. did not meet this requirement, did not avoid conflicts, and acted in their interests. Although all 5 directors did not meet their official obligations, Blake is a lawbreaker. Not all actions of directors that led to negative consequences are considered direct violations of the Corporations Act from the point of view of the law. All directors except Blake can adhere to this concept. The basis of the defense strategy will be the conviction that there was no self-interest in the decisions made, referring to Section 181 of the Corporations Act. Since the decision to expand and lend was made for the long-term development of the business, it can be appealed that the directors acted in the organization's interests. With the situation of Blake acting in his own interests, it is impossible to prove the absence of selfish motives. It is, therefore, necessary to mention that the other directors were unaware of his use of the client base. E.g. directors can rely on the fact that their decision was balanced and informed and that their intentions were sincere. If the company has calculated the risks and payback, this strategy can be pretty successful. There is no information in the text on which data decisions on expansion and lending were made. Perhaps the leadership strategy could have been successful if not for Blake's illegal activities. If the EG had expert advice, the directors could justify the company's actions by trusting the opinion of professionals. The directors are expected to conduct complex examinations before making a pivotal decision. Appealing to the trust of the management team can be a reasonably successful strategy. Not all directors were competent enough to make decisions about lending and the cost-benefit implications. For example, Emma may defend herself because she asked for advice from the more competent Aaron and Blake, but there was little independence in her actions. Unfortunately, the argument in the EEG case regarding the innocence of Blake is not convincing enough. Carlos may have a winning strategy if he spent most of his time in the hospital and did not directly participate in activities. Blake's guilt can be proved if the other directors provide evidence of their ignorance of his running a parallel business. The directors will not be held criminally liable for the company's debts. However, it is necessary to prove Blake's direct involvement in the EEG bankruptcy. Conclusion: failure to comply with the requirements for directors' obligations prescribed in the Corporations Act led to the bankruptcy of EEG. None of the 5 directors proved to be competent enough to lead the organization out of the crisis. Ignorance and self-interest are the main violations of official duties. The EEG director protection strategy may rely on undue trust in more senior team members or an expert counsel. However, this protection strategy may not be successful, and all the directors will face the consequences of their decisions.